With divorce cases on the rise, the family court has been given new powers in handling such cases. Speaking to lawyers and judges at Subordinate Courts Workplan 2011, Chief Justice Chan Sek Keong shared the new initiatives, which include mandatory post-filing counselling and mediation for divorcing couples with children.
Custody and care of the children are by their nature the most intractable of post-divorce problems. Accordingly, the Women's Charter has been amended to make counselling and mediation mandatory in such cases. It is hoped that such conciliation procedures will make it easier for parties to agree among themselves on the care and control of the child or the children.
With the rise of marriages between Singaporeans and foreigners, 2 new initiatives were introduced to address cross-border divorces. The first ensures that the party in custody of the children be granted alimony even though his or her ex-spouse is overseas.
We recognize the validity of certain divorces that are granted by foreign courts. A natural extension of this is the recent amendment to the Women's Charter and the family to give the family court power to make ancillary orders for division of matrimonial assets and maintenance for these foreign divorces where, for example, the parties have a sufficient connection to Singapore.
The second initiative protects the rights of one parent should the other parent take away the child to another country without the former's consent.
The International Child Abduction Act was passed last year and will come into force on the 1st of March this year. This act gives effect to the Hague Convention on the civil aspects of international child abduction. A child may be removed out of the country by one parent from the other parent in breach of the custodial rights of the parent who has been left behind.
CJ Chan also provided an update about the Mental Capacity Act, which came into effect in March 2010.
Last year I spoke of the Mental Capacity Act, which was a timely piece of legislation. The majority of the cases are applications concerning the appointment of deputies to take care of the personal welfare and or property and affairs of the elderly who are suffering from old age disorders such as senile dementia. With a fast aging population in a relatively affluent society, the number of such kinds of applications is bound to increase.
CJ Chan also addressed the issue of the high number of criminal cases that were dropped even before the trial date. Last year, 43% of cases did not make it to trial because those involved chose to resolve their dispute before the trial date. In some cases, they did not even show up in court. However, year-long initiatives to rigorously review magistrates' complaints has been successful in weeding out complaints with no merit.
Last year, 4,157 magistrates' complaints were filed, but only 55 summonses were issued. So this has resulted in a more efficient use of court and police resources.
Catch the full speech by Chief Justice Chan Sek Keong on the Subordinate Courts website.